now request Sister Bela M.Trivedi to share her views.
Good afternoon, everybody. Dignitaries on the dais, off the dais, invited guests, and friends. I know that eminent speakers are there to speak on the subject, but since we are also supposed to express our views in few minutes, so I thought let me jot down my few views and I'll present them. First of all, I would congratulate and compliment the Bar Council of India and its collaborators for organizing such a wonderful event on very vital issues, global issues. They are vital because global issues are nothing but the issues of individuals only. As we know, the universe is one, and the fundamental law of universe is the law of divine oneness, which says every thought, every action, every event beyond our senses is some way connected to anything and everything else. Everything in the universe is in constant motion, and every motion has a vibrating energy which has corresponding ripple effect. So whatever happens in the universe ultimately touches to the individual being also, directly or indirectly. And therefore, someone has rightly said, as above, so below, as within, so without. Justice Sundresh quoted a quote of one astronaut. I'll quote another. Sirisha Badla, the third Indian origin woman to become the astronaut after Kalpana Chawla and Sunita Williams, she had reacted in an interview after her ride to almost 90 kilometers above the Earth in July 2021. She said, looking at the Earth and seeing the thin blue line of atmosphere really brought me a perspective of how lucky we are and how fragile our planet is. It was incredible to see. I was looking out at the southwestern part of the US. We talk about states, but I saw no borders. And it put me into a perspective how divided we have become. And seeing brilliant Earth against the mad black void of space made me feel small, but not insignificant. So I returned to the planet, energized to pursue positive change for good and really appreciative of what we have. So in this era of globalization, the paradox is, though the political maps show boundaries between the countries, those boundaries disappear when it comes to competitive maps. The globalization, which has integrated the economy of one country with the global economy, and in turn allowed free flow of information, technology, goods and services, capital investments, has in fact created a borderless world. There is a paradigm shift in the world market from the traditional trade activities to a high-tech global trade and commercial activities. The use of smart contracts, the use of blockchain in the cryptocurrency systems have brought massive transformation in the world trade market. I would highlight cryptocurrency system because it has become a very game changer in the sense that cryptocurrency, which is also a digital asset, though is not considered to be a legal tender, is functioning as a medium of exchange akin to money. Since cryptocurrency does not have any legal tender and there is no regulatory authority in place, it is easy to trade between the countries. The nations are still grappling with the new world order of financial activities as to how to regulate digital currency, which has the tendency to be used in illegal activities and in turn misuse of financial systems for corruption, money laundering, terrorism, proliferation of weapons, and mass destruction, and of course, environmental issues also. Corruption and money laundering have wide-ranging impact on the nation's political, social, and economic development and stability. Such illegal activities have emboldened the organized syndicates and the terrorists. Corruption, that is bribery of or theft of public funds, is generally committed for the purpose of gaining illegal funds. And the activities of money laundering are done mainly to conceal those illegal activities. Today, the New World Order is also grappling with the proliferation of terrorism, armed conflicts, confrontations, and power struggles, which have led to problems of varied dimensions. Though international humanitarian law is part of the public international law, it has failed to attract adequate attention of the states and the international organizations. The environmental degradation and climate change, which have already been dealt with by my previous speakers, and I'll cursorily go through, have also entailed serious threats to the global community on the planet's ecological balance, human well-being, and sustainable development. Much has been debated, much has been deliberated upon, and much has been acted upon also. But the climate change and the environmental degradation have continued to pose serious threats to the planet Earth, impacting ecosystems, economies, and human security. The climate change is also significantly impacting the world's oceans. The high seas, the areas beyond national jurisdiction, cover almost 2/3 of the world's oceans and are home for diverse ecosystems and species. Legal framework for addressing climate change in the context of law of the seas are still evolving. The law of the space is also at the crossroads, facing numerous global issues that require careful consideration and international cooperation. As the number of satellites and spacecrafts in the orbit continues to rise, effective space traffic management is essential to prevent collision and ensure the safety of space operations. A lack of coordination can lead to close encounters and increase the risk of accidents. Unlike public international law, private international law has the framework that serves the guiding compass in the world, where the legal jurisdictions of the states often overlap and the boundaries of national sovereignty blur. Private international law dwells into the issues spanning multiple countries and encompass aspects like inter-country adoptions, international commercial transactions, human trafficking, etc. The International Institute of Unification of Private Law and other international organizations have streamlined the treaties, model laws, and other tools to control the domain of transnational conflicts, and in addition to the regulation established by the national authorities. Lastly, I would say we do have various global organizations working very actively and effectively in shaping and resolving the issues pertaining to the public and private international law. But they all work in silos and not in tandem. They do not intersect, they do not collaborate or work in cohesive manner. So what we need to do is to have a robust framework for addressing cross-border legal issues. The nations will have to continue their efforts to harmonize the laws and to create efficient and effective mechanism for the recognition and enforcement of foreign laws and the judgments. Thank you so much. Thanks for giving me this opportunity.
Justice Ashutosh Kumar from the Patna High Court would next share his views.
Thank you, sir. Honorable Justice Sanjay, Kishan, Kaul, Honorable Justice Sundresh, Honorable Justice Bela M.Trivedi, Honorable Judges of the Supreme Court, Mr. Wilson, Senior Advocate, Lubna, Shuja, President of the Law Society of England and Wales, Mr. Desai, Senior Advocate, Bombay High Court, Mr. N. Koteshwar Singh, I see in the audience, Chief Justice of J&K, Dr. Anita Sumant, Judge from Madras High Court, my friends, advocates from different states, members of bar councils of different state chapters, and I see many from Bihar as well. Well, very good afternoon to all of you. Justice Kaul reminded all of you about Mohandas Karamchand Gandhi's statement that world has everything that the mankind needs, and the world would be deficient for the greed of mankind. And Justice Sundresh says, he quotes from a very famous poet's couplets, says, world is mine and all are my relatives. I think the global perspective lies somewhere in between. Schumacher, one of the philosophers, he said that the world is small, world is flat. Now he was very, he was thinking in future. World definitely is the globe today is very small. It can be traversed, it can be accessed by anyone in no time. See, what is the purpose of globalization? What is the purpose of a law which looks at global issues? What is the difference between globalization of law and globalization in law? These are some of the concepts which would be readily answered if we see what has been happening all these years. Not that it is a new concept. We are not writing something on a new slate. It has been in the past the experience that with the efforts of world leaders, the nations, when they have walked and have kept pace with the stride of the world, the resolution has come forward. See, in our increasingly interconnected world, the global issues require global solutions. This is the topic today. International law plays a very pivotal role in addressing these challenges by offering a framework through which the nations can cooperate to tackle common problems. The debate today, and rightly so, is whether national states can effectively regulate phenomena which are intrinsically global in nature, such as climate change, immigration, human rights, food and health security, etc. With the coordination amongst nations, these issues can be handled in a more comprehensive and sustained manner. Justice Trivedi was right when she says that if nations work in silos, perhaps no more development can be thought of. There has to be a united effort. Globalization, we must reckon, there is a fear amongst people that if we go a lot for globalization, perhaps the very concept of the dominions, concept of the sovereignty would be reduced to something which is not acceptable readily. It brings some uneasy friction between local and global, domestic and foreign, and perhaps local and universal practice. There is a need for a body of transnational law or global law which may be perceived as internationalization of law or globalization of law. There is a dialectic relationship between global and local law. I was just discussing it with my friend Mr. Desai, senior advocate who practices primarily on the international side. This can be better understood by appreciating the distinction between what we call the law of globalization and what happens to law when globalization occurs. The example in law of globalization would be contract law, which would require to be broadened in the new global scenario in comparison with family law, which can be allowed to remain untouched. In the law in globalization, the goal is to create an ecosystem which would cater to the growing global interactions between nations. Are we then looking at a unitary body of rules with universal application? I mean, that's the first question that confronts us. Or would it be necessary to address the multiplicity of legal systems and their interactions, which means acknowledging a pluralist perspective about the problems and its solutions? I would quote from Thomas Frank, his idea about globalization of law and how to deal with it, and why the international set of rules are being respected without there being any coercive system inbuilt in these treaties which are being followed by the nations. So he's one of the most celebrated international law scholars. He says that he conceded, actually in his theory about legitimacy of international law, he concedes that international law is not the law in the same sense as municipal law. But he admits of being heavily struck by the fact that without any coercive power behind most of the international law rules, many of such rules have very frequently been followed by many states. Why? He acknowledges that there must be something else which is responsible for such obedience. The factor responsible, according to him, is the legitimacy factor, which actually makes it justifiable, acceptable by nations, implemented by nations, and the municipal laws. The overall picture which has emerged today is that there should be emphasis for a robust international framework which can effectively respond to complex and interconnected challenges facing the global community. Who would deny that with the increased global connectivity, there is greater importance of trade and economic cooperation amongst nations? The World Bank, the IMF, the International Trade System, all of this began as a general agreement on trade and tariff, which developed into a full-fledged World Trade Organization. This was post-World War II development, and this reflected Montesquieu's Dow commerce. Dow commerce, according to him, it has a civilizing effect. Civilized nations follow others. So this was one of the examples. The dispute settlement body of the WTO ensures that countries adhere to their trade obligations, thereby preventing trade wars and promoting economic stability. On the other end of the spectrum, away from economy, which is a conception of law, a global conception of law, which deals with humanity as a whole. Now, one of the newer known scholar, Salem Hikmat Nasser, refers to it. He gives a very good name to it. He says it's an axiological motor of globalization, human rights, laws protecting human rights. So international law plays a very crucial role in preventing and mitigating armed conflicts between nations. That is what is really afflicting us today. The UN Charter prohibits the use of wars in international relations except in cases of self-defense or when authorized by UN Security Council. The international humanitarian law as embodied in Geneva Conventions, they seek to protect civilians and combatants who are not taking part in the hostilities during armed conflicts. Another aspect, the global refugee crisis. This continues to be one of the pressing issues with millions of people displaced from their homes because of conflicts, because of persecution, and environmental factors. The 1951 Refugee Convention and its 1967 protocol provides a legal framework for protection of refugees and their rights. All this is international, all this is global aspect of law and its impact on municipal laws. One of the notable examples of such resolution at the international level is the verdict of the European Court of Human Rights in the case of MSS versus Belgium and Greece. I think all of you know about it. MSS was an Afghan national who had entered Belgium through Greece. And there it was found that the conditions, his reception was very bad. The conditions under which MSS was living, it was so bad that it required, intervention at the world level. So this judgment by ECHR, it has highlighted the responsibility of European member states to ensure human conditions for asylum seekers. Another very important case, Nicaragua versus United States, 1986. The ICJ, International Court of Justice, viewed the US support of Contra rebels in Nicaragua to be violative of international law, notwithstanding the supporters. Cybersecurity, as flagged by Justice Kaul and Justice Trivedi, is yet another global concern. You're aware of a privately formulated Tallinn manual, though it has been formulated by people from all over the world without any official capacity, but it is accepted. It is accepted as a good manual, a vade-mecum for cyber security, cyber crimes, and its resolution. It has been produced by an independent group of experts, which offers guidance, and it is acceptable to all. Not that it's true for only the nation which actually hosted this, where it was formulated. Now, beginning with SS Lotus case between France and Turkey in 1927, Suez Canal case in 1956, apartheid cases, Bosnian genocide case, the judgments of International Criminal Tribunal for former Yugoslavia between 1993 to 2017, all of this international law has helped resolve the crisis. Particularly E.C. Harmon's case, I think I must refer to it shortly just to arouse your interest. One must know who the audience is. There are young children, young students sitting at the back. They must know what E.C. Harmon's case is. It has not been resolved as yet, but then it has led to some developments in the thought process, which is actually the purpose of globalization of law or globalization in law. E.C. Harmon's case, the dispute in this case was, it triggered when the European community banned the import of beef with synthetic hormones. Synthetic hormones were suspected to be affecting people's health. The ban caused the export from US and Canada to drop drastically. The dispute persisted for more than 2 decades. But one of the effects of this case was that US public opinion was awakened. Even though the tariff had gone down, the public in US, the opinion was not completely unsympathetic to European Union. The impact was that public in general got motivated to purchase organic or natural meats. It has not yet been resolved, let me tell you. But then the positive impact of it is worth noting. I would also like to refer to the massive proliferation of international institutions that have altered the traditional politics of interstate relationship. Responding to 9/11 attack, the UN Security Council has come out with a slew of resolutions which have developed into somewhat global system of standards, expectations, reporting and assessment, and seeking and demanding universal state action against acts of terrorism. You see what's happening in Canada. You see what's happening in US, what's happening in neighboring countries. Unless the world comes forward, the resolution would not be forthcoming as easily as it would if all of us strive together and not work in silos. The European Union has come out with a corpus of supranational laws in the field of agriculture, competition policy, energy, human rights, monetary affairs, public health security, and trade. International tribunals also have become centers for coordinating policies. Now, we must admit and not grieve that in this world, the coexistence and overlapping of different norms do not eliminate local distinctiveness. Talking about global law and globalization of law, we are not harping on something where one loses one's identity. The state law must be adaptive. There is always a somewhat unreasonable but lurking fear that with the diminution of traditional national borders because of transnational forces, the sovereign state may not be in a position to maintain the fiction of absolute sovereignty as well as its constitutional autonomy. I, for my part, strongly hold the view that globalization does not marginalize the state law. Rather, it makes the state law expansive in its reach. And then the UN Declaration of Human Rights, which talks about dignity, which talks about fairness, which talks about freedom of all fear, and particularly the freedom from want. That's what we are looking for. Climate change, again, is a global issue. There is greenhouse gases emission, rising temperatures, sea level rises, extreme weather events, we sitting in Delhi or in Patna, we only don't face this. The world is facing it. Because of the efforts of international bodies, many solutions have come to the fore which are being piloted and are being taken forward by nations. All this is the effect of globalization. Look at these efforts at transition to renewable energy, energy efficiency, reforestation, afforestation, carbon pricing, and collaborating globally through agreements like Paris Agreement, where it sets targets for reduction targets for carbon emission, and sharing the best practices. So after all, everybody's motto today, as Prime Minister also said today in the morning, one earth, one future, and therefore the globalization of law for resolving global issues. Thank you.